And joining us in studio is Minister of Justice and Correctional Services, Advocate Michael Masutha. Good morning to you and thank you so much for joining us. I think let's just break it down, especially when we deal with what the prescription of the law said before the Constitutional Court ruling.
Yeah. Where it comes from is that at common law, which is your Roman and Roman Dutch law, which is still part of our law, we inherited it upon colonization when the Dutch came here. Because that was the law in Holland at the time, although Holland no longer uses Roman Dutch law because their law is codified. But essentially, under that law, all criminal offences prescribe after a period of 20 years. Now, through Section 18 of the Criminal Procedure Act, there was a statutory reform to the common law, if you like, in terms of which certain serious offences were made not to prescribe after 20 years, so they don't prescribe at all. This includes certain sexual offences such as rape, etc. But what Section 18 did not do was to lift prescription with regard to all sexual offences. So there were only a specific set of offences that were affected. So the ruling effectively says there is no reason why you should leave out certain sexual offences and that all sexual offences should not be subject to prescription. We have since introduced a bill in Parliament which, ahead of the judgment, which sought to remedy the situation, but it's clear from the judgment that the bill is not going far enough, which means that we're going to have to review it or substitute it whilst it's going through the parliamentary process.
Yeah, is that because law as a discipline is also subject to interpretation, that perhaps we haven't found the mechanism to deal with specific crimes of sexual violence or assault, child molestation and that?
No, the law is very clear. It's always been very clear. What was at issue is not legal uncertainty. In fact, there was legal certainty. It's just that the way in which the law regulated the matter, the court found was unconstitutional, in that it left out certain offences from being no longer subject to prescription. So essentially what this will do is it will enable, say for example, people who were the victim of sexual offences when they were still children or were in a state of vulnerability in some form or another and therefore not in a position of power relations, for example, with a perpetrator, to be able to assert themselves and seek justice. When they eventually become more empowered, because their circumstances may have changed one way or the other, and therefore feel that they are in a position to seek recourse, but for the fact that 20 years have lapsed in the meantime, which makes it impossible for them to then pursue the matter, that limitation would then be lifted off so that they're able to pursue the prosecution.
What then, especially if you talk about a time frame where perhaps evidence wasn't collected or some information the victim is not able to recall, there may not be witnesses, just the complexity of having to prove a case beyond the statute of limitation or the 20-year period?
Yeah. Look, the issue of evidence have absolutely nothing to do with the prescription period, all right? It's a question of whether you are able to put together a case based on evidence that is unassailable, that the court can accept as constituting evidence beyond reasonable doubt, because that is the threshold, that is the standard in standard of proof in criminal matters that has to be met in respect of any criminal offense. So the problem of evidence in sexual offenses will always be the same challenge in respect of any other criminal offense, in that if you say somebody assaulted you physically or verbally for that matter, you might not have the evidence to back that up, or you might fortuitously stumble upon evidence that is adequate. There may have been a video clip that was never erased 20 years, 30 years down the line that comes forward that is conclusive proof of something that took place way back. You know, the issue is whether in that specific case it is possible to gather sufficient evidence to satisfy the court beyond reasonable doubt that a conviction is due.
So will this then be an automatic, a fait accompli that if there is an allegation that there will be an automatic prosecution, or is it still subject to the process of gathering the required information?
Okay. Every criminal case has to go through the following steps. First of all, there has to be a complainant who must lay a charge at a police station, provide whatever evidence that they are able to provide to the police. If there is evidence that the victim may not themselves adduce, but which through investigation can be established, that evidence would equally be relevant. And of course, once the police have completed their investigation, they must decide whether they have a solid enough case to present to prosecution. Prosecution evaluates what is being put forward to them by the police to determine whether there is a sufficient case to prosecute. And of course, if there isn't enough evidence to go by, and there are no other ways of, and by the way, evidence includes witnesses' testimony. And it depends on how witnesses also perform in court, especially under cross-examination. So it doesn't have to necessarily only be a matter of physical forensic evidence only. In fact, forensic evidence on its own is not sufficient in some instances to secure a conviction. You might still want to embellish that with testimony of witnesses.
You were saying that essentially this is a milestone, especially for child molestation, human trafficking victims, but in also not creating what one could call a legitimate expectation that their case has got the prospects of success are guaranteed, that it would still have to go through all of that process.
There is no way that one can guarantee the prospects of success of any case, civil or criminal, until the third lady has blown the whistle, so to speak, which is until the court has pronounced itself. So at the end of the day, it's a matter of what evidence is there against the legal principles. You know, for any crime to have been committed, there's 4 elements that must have been met. And if any one of those 4 elements are missing, there cannot be a conviction. All right?
So how would this then still encourage sexual offences survivors to come forward, and especially in the case that we cited of Sidney Frankel, where he's deceased? It brings another dynamic to whether there'd be a success or not of prosecution.
Yeah. What I would say is that if somebody feels that they've been violated and they feel that they want recourse, they shouldn't sit back and give in. They should give it a go, consult the authorities, state their case, see what help they can receive to put together a solid case. It may well be that where you're sitting, you might think, I don't have much to go by to really build a solid case, but upon investigation, Lord behold, the investigation authorities may stumble on evidence that is solid enough which you were not even privy to, and which could provide sufficient basis to secure a conviction. So the encouragement really is to victims to say, don't let in, don't give in easily, all right? If you feel aggrieved, come forward.
But generally, civil rights groups and society in general will lament the lack of conviction, or that the system fails rape survivors, and many refusing, or rather withholding the information and living with their burden, because there is just this trust deficit in the system.
Yeah. It is for that reason that we created a special dispensation for victims of sexual offences. The creation of sexual offences courts, our target is to establish about 110 throughout the country. We're currently at 75. And also to Tuzala centres, which are aimed at providing a holistic one-stop service to victims of sexual violence. And this includes the provision of counseling, the provision of prophylactic treatment if you approach within the 72-hour window, so that you're protected from secondary harm as a result of, say, sexually transmitted diseases, etc., or issues of pregnancy, etc. But also, these courts are designed to cater for the peculiar and sensitive nature of sexual offences prosecutions, where you have to ensure that the victim can testify in camera, where prosecutors are trained so that they don't further harm the victim in the manner in which they handle cases, that people on the bench, the magistrates or the judges, also have the necessary sensitivity in handling this matter. So that's another way of giving assurance to the victim that they will be dealt with separate, differently, as a special case within the criminal justice system, because of their unique circumstances.
And I understand that there are all these laws and reforms that had been done to ensure that there is justice for victims of sexual offences. But just as a society, one could argue that, the moral fibre has deteriorated, it's decayed, that even the harsher sentences have not protected or deterred perpetrators from committing murder against their intimate partners. Child molestation is still a reality in society. Where do you think is the disjuncture, that there is an imbalance somehow? If the law was strong enough, perhaps we could have seen a reduction in sexual violence and femicide.
One of the initiatives we've embarked upon as the Justice and Security Cluster is to pull our resources into working on a coordinated research to understand the different crime typologies, in order to really understand the underlying drivers, for purposes of developing better preventative strategies, whether through public awareness, through education at schools, because it in some instances starts right at childhood, both at home and at school. How we raise our children, especially boy children. And therefore, it needs an integrated and a multi-sectoral approach that deals with the entire value chain, from prevention to effective prosecution and, of course, rehabilitation, so through correction. So the entire value chain, we're actually reviewing it to look at where are the weaknesses in the system. But of course, we cannot escape the reality that these are largely socially driven criminal offenses or criminal conduct, and that we need to address the underlying social factors that drive this. You will notice, for example, that in depraved social environments, where there's overcrowding, where there's general degraded human living conditions, that comes with a sense of a diminished sense of dignity and self-esteem. And those environments, if corrected, and I'm not saying they're the only factors, because you still find in affluent places, you talk of the Karabo Mokoena matter, where issues of poverty did not arise, and yet the gruesome, femicide and so on. So we do need to understand the various circumstances that drive this violent behavior in our society.
Minister, and also just lastly and very briefly, what do you say to what seems to be a social psyche, that there is this criminality? Criminals have become more brazen. We've seen an increase in cash in transit heists. We've seen increase in random murders, or what would seem like, just general lawlessness. What is your response to that?
I think it's we shouldn't feel despondent. I think that we do need to focus on certain factors which we believe are contributory factors. I think the notion of a radical socio-economic transformation agenda, which the ruling party and the government of the day is pursuing, is one very critical pillar, I believe, in reversing some of the underlying socio-economic environments that I alluded to earlier, which do propel incidents. I mean, if you look at some of the coloured and black townships in the Western Cape, for example, where there has been unparalleled levels of violence, including sexual violence and murder, you immediately see the connection between that and the depraved socioeconomic conditions there. So,
Minister, we're going to have to leave it there. I do beg your pardon.
Yes.
Thank you indeed for joining us as always. So that's a Minister of Justice and Correctional Services, Advocate Michael Masutha, speaking to us on the Constitutional Court order that the prescription for sexual offences when it comes to child molestation and human trafficking will now be extended beyond the 20-year limit. Do stay with us here on Live Report. We'll take a quick break. We'll see you shortly.